Hi, and welcome to this latest immigration law update video. In this video, I wanted to summarize a recent decision from the Court of Appeal called Kaur. It's 2023 EWCA Civ 1353, and it's a decision from the 17th of November 2023. And this case concerns Article 8 and proportionality assessments, particularly in the context of where there's been deception by an appellant. So it's a decision of the Court of Appeal and judgment given by Lord Justice Stuart Smith against the decision of Upper Tribunal Judge Gleeson. As we're going to see, this is a helpful case which you may want to use when doing representations in Article 8 cases, perhaps when drafting skeleton arguments, and when challenging decisions where there's been an inadequate assessment of the Article 8 claim. So this concerns a refusal from 2015 when the Home Office cancelled the appellant's leave because she'd been found to have a fraudulent English test certificate. Now, eventually, the decision came before the Upper Tribunal in 2022. Upper Tribunal Judge Gleeson found that there had been deception in terms of the English language certificate and dismissed the Article 8 claim outside of the rules. If you look at the screen, you'll see paragraphs 5 to 8 set out the factual background. And of particular note is that the appellant in 2009 met Harjinder Singh. At that time, he was here illegally. He subsequently, in May 2010, got indefinite leave on the basis of the rule at that time, 14 years long residence. On the 27th of June 2010, the couple married, and in 2012, he became a British citizen. The appellant was stopped on her return from a visit from India in 2015, and that led to her leave being cancelled on account of the ETS TOEIC certificate. The Court of Appeal then set out the judgment of the Upper Tribunal, and you'll see that the Article 8 is dealt with very briefly. The focus of the judgment of the Upper Tribunal was very much on the deception aspect. The permission to the Court of Appeal was only on Article 8. The deception findings weren't challenged. And paragraph 16 of the Court of Appeal set out the very brief paragraph 73 and 74 that dealt with Article 8 in the Upper Tribunal decision. The Upper Tribunal says there is no evidence of the family disapproval relied upon. The appellant's accounts and that of her husband as what she did when she went back to India is discrepant. The appellant says she went in 2015 to see her mother, but her husband says she went in 2014 to a friend's wedding and did not see her family. At 74, the appellant is not currently receiving any in vitro fertilization because the respondent has her passport on her account. There are no significant obstacles to her reintegration in India on return, nor indeed are there any insurmountable obstacles to this couple living in India together, of which they are both citizens? So the Article 8 claim that had been advanced in this case was that this was a love relationship, that the family in India disapproved of the relationship. They received one round of IVF, but the appellant said because she hasn't got a passport in the Home Office, she can't receive a second one. And the husband was now British and settled in the United Kingdom with his business. It was accepted, paragraph 18, that the suitability refusal was sustainable because of the deception. So the appellant's Article 8 claim was outside of the rules. At paragraph 19, the Court of Appeal set out the guidance in respect of Article 8 outside the rules. And it says this in the second sentence of paragraph 19, the third sentence: the decision maker must in every case consider whether there are exceptional circumstances which warrant a grant of leave outside of the rules on Article 8 grounds. In doing so, the decision maker must consider all relevant factors raised by the applicant. Exceptional does not mean that the circumstances must be unusual or unique. It means circumstances in which the refusal would result in unjustifiably harsh consequences for the individual or their family, such that the refusal of the application would not be proportionate under Article 8. So, proportionality assessment outside the rules, all matters are relevant to that. All considerations must be factored in there. And that's what they say at paragraph 20. In determining whether there are exceptional circumstances, the decision maker must consider all relevant factors raised by the applicant and weigh them against the public interest under Article 8. And we're going to see in this case that was not done by the upper tribunal. At paragraph 21, they set out the leading judgments, which summarise the approach to Article 8 in these type of in-country cases. That's Agiarco from the Supreme Court in 2017 and the helpful summary in GM Sri Lanka in 2019. So if you're preparing representations on Article 8, and particularly in a sort of insurmountable obstacles, 10-year partner route case, I'd recommend having a look at GM Sri Lanka from 2019. Paragraph 22 summarises the issue. So the submissions on behalf of the appellant was that the judge had not done a proper Article 8 balance at all in paragraph 73 or 74. Or if she had, she'd missed out a considerable number of factors that weighed on behalf of the appellant. The Secretary of State argued against that, well, saying, well, no, she did have all these factors in her mind, and in any event, the decision would be the same anyway. Now look at paragraph 23, because this is important. It says this: as a preliminary point, I accept that the relevant evidence before the upper tribunal judge was limited. In particular, there was either no or virtually no documentary evidence to support the appellant's claims, e.g. about her IVF treatment. Now, just pause there. That's so important. If you're preparing representations in an Article 8 application, and I hope when you submit your application, you do submit them with detailed representations, have you properly set out the different factors that you're relying on cumulatively as part of the Article 8 assessment? And it's worth doing that, just literally listing all the factors. So in this case, it was the IVF treatment. It was the family disapproval. It was the fact the husband was British and was settled during another business year. Set them out, but most importantly, evidence those things. Let's carry on. Paragraph 23. To that extent, I accept that a proportionality assessment could properly be relatively short, reflecting the fact that the evidence at the hearing and consequently the judgment appeared to be primarily taken up with the deception claim. So primary issue was deception. So in a case like this, it's likely that an Article 8 assessment will be pretty short. Paragraph 24, the judge rejects the family disapproval point, and it was accepted that she was entitled to do that for the reasons she gave. But now we come to where the Court of Appeal find there are problems with the upper tribunal judgment, and this is probably going to be most helpful to you when you're drafting your representations or you're drafting grounds of appeal trying to challenge an Article 8 assessment. So turning to paragraph 74, there are three aspects to the paragraph. First, the upper tribunal judge records that the appellant's account that she was not currently receiving IVF because the respondent had her passport. But then look what they say, but she makes no finding about whether this account is accurate or not, nor does she explain what, if any, weight she attributes to this factor. And thirdly, then, it's not clear whether she's treating this as a factor for or against the appellant. Secondly, in regard to paragraph 74, look at paragraph 26. The judge finds there are no significant obstacles to the appellant's reintegration in India. Again, there is no indication of the weight that's attributed to this factor, nor there's an indication of the reasons as to why the judge reaches the conclusion that there would be no significant obstacles. The third factor, paragraph 27, is about insurmountable obstacles. So whether there are insurmountable obstacles to the couple residing in India. Once again, the Court of Appeal says there is no reasoning to explain this conclusion and no explanation of the weight that is being attached to it. What does appear, however, is that the conclusion is influenced by the UTJ's statement that both the appellant and Harvinder Singh are citizens of India. This statement was wrong, since there was documentary evidence in the form of his UK passport that Harvinder Singh is a British national, and no evidence that he held dual UK Indian citizenship. To my mind, this was a material error because there was no basis for assuming that Harvinder Singh would be able to live in India with the appellant as if he were an Indian citizen. So again, no proper conclusions and reasoning in respect of insurmountable obstacles. And what was mentioned was wrong because Harvinder was British and there was no evidence that he also held Indian citizenship. So the Court of Appeal have rejected the sort of 3 points set out of paragraph 74. And then at paragraph 28, they say more generally, paragraph 73 and 74 do not represent a proper proportionality assessment. There's a number of factors that are not mentioned. So look at paragraph 28. The UTJ does not mention the length of the appellant's marriage, the nature of a relationship with her husband, nor does it mention that although Harvinder Singh had originally been a clandestine migrant, by the time that he and the appellant had married, they were both lawful in the United Kingdom. Don't mention that he's been British since 2012, the difficulties he might face if removed to India, and how that might exacerbate the difficulties for the appellant herself. On the other side of the coin, there's no mention of the deception finding. Clearly, the fact that there had been deception in respect to the English language is going to weigh significantly in the proportionality balance. They say that, look, this is not a comprehensive catalogue, but this is just examples of where there's been a failure to weigh the material matters in a proportionality assessment. In paragraph 29, what hasn't been done is a proper balancing exercise. And the Supreme Court have talked about the balance sheet approach, which clearly sets out and transparently sets out the factors for and then the factors against and reaches a conclusion. Now, whilst they have some sympathy for the upper tribunal judge because the focus was very much on a deception case, we've got to remember that ultimately these appeals are on human rights grounds. The right of appeal is on human rights grounds, and there needs to be a proper assessment. Now, as representatives, we need to properly lay the table. And that's why I've said in the representations in the skeleton, set out the factors that you're relying on and then cross-refer to the evidence. But they find that the upper tribunal judge has erred in failing to properly conduct a balancing exercise. And then that is material to the outcome by failing to consider material factors, and that those factors that were considered were arguably wrong in relation to Harvinder's citizenship. They reject the submission of the Secretary of State that it would have made no difference to the outcome of the case. So I think this is a helpful judgment in terms of preparing your Article 8 cases, particularly in cases involving insurmountable obstacles. But you'll also find some help here when you're challenging judgments where there's been an assessment on insurmountable obstacles or Article 8 outside the rules, and you're seeking to say that it's an inadequate assessment. I hope that's helpful to you. I'll put the link to the judgment below the video.